Legal Director for the Institute for Constitutional Advocacy and Protection at Georgetown Law, Rupa Bhattacharya. Rupa, thank you for joining us. And your colleague was actually arguing in front of the Supreme Court today, and both of you represent those 5 pregnant women who had sued the administration. So I want to first just get your take on what was your takeaway from how this went today? What surprised you the most?
Well, thank you so much for having me today. It was definitely an interesting day in the court. I think that the Supreme Court is concerned about the extent to which district courts are entering into these nationwide injunctions, but also understand that there are some places where it might actually be the right thing to do. And so you heard a lot of questions today about what are the alternative avenues for getting this sort of relief? What are the practicalities for getting this sort of relief? How quickly can these cases be heard so that broader relief can be entered? And so I'm very curious to see where they're going to go after the argument today.
Because at the core, the question they were trying to answer is, can a singular federal judge block nationwide policy? After hearing the arguments today, do you have a sense of which way they're leaning?
Well, I never predict the court. I think that's a fool's errand. But it was interesting to me that so many of the justices were concerned about the practicalities of how cases get before the court and whether or not that would get any better or worse under any of the sort of alternative vehicles that the government was suggesting. And I think that may be something that they're really concerned about. Obviously, we've seen a lot of these sort of emergency motions come before the court. I think they're worried about their own dockets, but they're also, I think, worried about how to make sure that people who need relief get relief. So we'll see how all of that balances out.
And even though the focus of this wasn't on the underlying issue of birthright citizenship, what did you make of what the justices said about the constitutionality of Trump's executive order banning birthright citizenship?
Yeah, so those who stated a view seemed to think pretty clearly that it was unconstitutional, but there were a number of justices that didn't speak to the merits of the issue at all. So it's hard to tell where they might currently be standing. I do think it's important, and my colleague Kelsey Corcoran made this point, that where the harms are so broad and the law is so plainly unconstitutional, it warrants sort of a broader amount of relief. Like there should be some sort of, you have to consider the merits at least a little bit in order to determine both whether or not the government is likely to succeed and whether or not the government is suffering any irreparable harm.
So you're saying the justices may agree that these federal judges shouldn't be able to so easily block presidential policy nationwide, but when it's so unconstitutional in this case, you're saying they should be able to.
Well, so I think that's one of the things that really surprised me about this case in particular and how it got to the court. The government's taking such an aggressive position here. This is the recognition of birthright citizenship in this country has been in place for well over a century. It's been blocked now by 3 different courts. So to the extent the government is concerned about percolating, we've seen that happen already. 3 courts have found that this EO is likely to be found to be blatantly unconstitutional. And yet they're still in court arguing that they are somehow harmed by following the same policy that they followed for over 100 years for the time that it takes to get this issue resolved. And that just seems like such a stretch to me. I find it quite surprising.
And in terms of the practical effect, I've been talking to some immigration advocates who are talking about the real chaos that could be caused depending on what the judges decide, because you could theoretically have a case where you're considered a U.S. citizen if you're born in one state but not another. I mean, what could this actually look like?
Well, so the argument the government is making is exactly that citizenship would turn on and off depending on where you were, in which state, and whether or not you cross state lines, or that citizenship would be determined by your membership in one of our plaintiff organizations, for example, CASA of Maryland or the Asylum Seekers Advocacy Project. That's sort of crazy. It is hard to understand how state governments, local governments, hospitals, benefits providers, all of which depend upon an understanding of citizenship would be able to execute that sort of a policy in any sort of workable way. And it certainly undercuts sort of the very fundamental nature of our union as the United States to say that people born in Tennessee are not citizens, but people born in Massachusetts are. The whole reason for the 14th Amendment and the reason it was enacted as part of our Constitution was to prevent citizenship from being dictated by the whims of political parties, of legislatures, of presidential administrations. Instead, it was enshrined as a constitutional right. And it is amazing to me that the government thinks that they can just take that away with the stroke of the president's pen or an executive order.
Well, Rupa, thank you so much for sitting down with us here in the studio and walking us through all of this. I know you've been incredibly busy. So thank you again.
Thank you so much.